giving me an opportunity to share my thoughts. I am no longer with SOAS, but I am now in independent practice. SOAS is where I read my LLM on a Felix scholarship and also gave me an opportunity to study different things that I could in my law studies. And of that was studying international law in domestic courts, and a jurisdiction like the United Kingdom is one which caught my particular interest and also curiosity. We began with trivia, and I'd like to continue in that same vein of form. Part 19 was finally elected to the PCIJ in 1921 to then adjudicate the Lotus dispute in 1927. In the case, he memorially noted, and I quote him here, the notions...
Apologies, I will interrupt you again because...
I hope the chair will be kind with time and management of time and is not going to hold this time against me. Well, Lord Finlay, as I was saying, he once said that the law of nations do not recognize the assumption of jurisdiction for protection. There has never been any such general consent by nations of the world. This thinking by Finlay is encapsulated not only in his words or his thought process, but also in an entire nation's thought process, thereby also by extension into the common law system. He encapsulates the imperative that jurisdiction must rest on explicit legal authority, a premise of England and its practice of presumption of jurisdiction, as by default. The precise carve-outs that are also enshrined in the State Immunity Act of 1978, which this paper shall discuss in depth. But there are other reasons why the British system, in understanding the practical implications, which is the core of this session, discusses. There is also a presumption of jurisdiction by default, as I said. It also inherits the Lotus principle on jurisdictional presumptions. There is also a strategy or a statutory judicial synergy, which you also see in the 1978 Act that I should discuss, but for now only refer to Section 10, which explicitly denies immunity to state-owned vessels engaged in commercial activities. It also applies a restrictive framework, ensuring that states cannot claim immunity for acts performed in a private capacity. This also extends to a predictive regulatory framework by marrying Lotus principles with a precedent-backed restrictive regime. England offers a transparent, forward-looking legal landscape. It is also the global benchmark for harmonization, perhaps also because of its commercial interests that started in some sense at the beginning of the colonial empire. To study the legal development of immunity in the British system, but not just limiting itself to the British system, but having a global overarching impact is the core of this paper, and I want to do it through cases. So we start this story in 1880 in the Parliament Belge case, which discussed the decision of foreign sovereign immunity on ships, and that they, as a complete banner, could not be arrested or sued without consent. This case also exemplifies the older and much more expansive view that any vessel owned and operated by a sovereign state, regardless of its function, enjoyed complete immunity from jurisdiction. We then take a high jump into the Port Alexander case of 1920, which discusses and also accepts the early enforcement of absolute immunity, which also introduced glimpses of a functional approach by exploring whether the cargo or vessel was commercial in character. Ladies and gentlemen, this is an important point, and the latest case that we will discuss later in this presentation discusses exactly this principle. But returning to Port Alexander, it must also be noted that the prevailing legal system still favored immunity for state-owned ships. The case nonetheless paved the way for later decisions whether a vessel's purpose should override its formal ownership. Onwards to the mid-century and the shifts towards restrictive immunity. Christina, in 1938, in the House of Lords, upheld non-interference with a Spanish state vessel that had been expropriated and was claimed to serve governmental function. This decision solidified the principle that once a court recognizes a foreign government's title, the vessel was immune from arrest, thus preserving the state's sovereign dignity. On to 1977 and the Philippine Admiral case, which accelerated the shift towards a restrictive theory. The Privy Council in this judgment underscored that immunity hinges on the nature of the act rather than the purpose. A state-owned vessel employed in commercial activities could be subject to maritime claims, an important departure from the once unqualified notion that sovereign immunity and ownership alone confers absolute immunity. We then see a refinement of concepts in the cases in that bracket. The House of Lords affirms the nature test under English law, distinguishing acts of state and acts of private nature, jure imperi versus jure gestionis. The political motives of a state's cargo transport seemed prominent in this case. The court insisted that the commercial character of the transaction was decisive for denying immunity. Alcom versus Columbia focuses on the intended use of relevant property at the times of enforcement. The House of Lords clarified that the property allocated to genuine sovereign purposes remains immune, whereas assets demonstrably tied to commercial ventures do not. Alcom alone reinforced the practical inquiry into whether funds or cargo are disentitled from government objections. In 1977, we see another replacement, that historical stances of absolute immunity with the firmly restrictive approach in the United Kingdom, ruling that a central bank's commercial letter of credit was not protected. Trent-Tex affirmed that commercial equality of the Act determined whether the immunity applied or not, thereby also realigning itself with concepts from other countries. What about the modern day? Well, in 2012, we saw the test for sovereign use first being used. It discussed the ruling that the property originally developed from government purposes but may lose immunity if subsequently attracted to commercial ends. This case also illustrates the scrutiny of actual use, preventing states from retrospectively labeling commercially exploited assets as sovereign to simply evade enforceability. The Argentum versus South Africa case, being the most recent, is showcasing a modern willingness to dissect the commercial or sovereign nature of maritime claims. The Argentum dispute addressed salvage operations over cargo historically linked to a foreign state, also linking back to England's dark and mysterious past of colonial Raj. I encourage everyone to read this case because it answers a lot of questions. Inter alia, whether salvage and subsequent dealings with the cargo were property of government or commercial. This underscored in its factual analysis is not mere state ownership that dictates immunity. What these cases in totality show us that the refinement of these principles ensures their relevance in contemporary maritime and commercial contexts. The evolution underscores the adaptability of domestic systems such as the UK in state involvement of global commercial relationships. Well, comparing these cases further, what I would like to discuss is the distinction between vessels and their cargo employed for sovereign versus commercial purposes. This underlies the most fundamental aspect of state immunity. While genuine sovereign activities attract immunity from adjudicative and enforcement jurisdiction, commercial ventures do not. The State Immunity Act of 1978 says, and I quote, that the restrictive adoption by extending immunity primarily to acts jure imperi rather than acts jure gestionis. What we see in these cases, especially Congreso, Trent-Tex, and also Central Bank of Nigeria, is that it underscores the state-owned cargo or vessel engaged in commercial transactions must forfeit protection, aligning itself with the state's claims and jurisdictions. Section 13 and 14 of the State Immunity Act may assume adjudicative jurisdiction where the state or its instruments engage in commercial dealings. Yet, when a state is subject to jurisdiction or merits or enforcement measures, especially those involving the arrest of vessels or attachment of cargo, require a nuanced inquiry into the property's use and purpose. Of course, this becomes much more relevant in the cases mentioned after Alcom Columbia towards Servas, because these cases signaled a rigorous inquiry into the understanding and the genuine purpose that the government faced with its links in commercial activities. Together, these decisions illustrate the progressive tightening of immunity doctrines, especially in the maritime sphere, where claims often hinge on immunity and commercial activity exceptions. This conceptual divide is pivotal in determining whether state-owned vessels and cargo vessels benefit from immunity. Immunity perhaps must be granted in military expeditions or diplomatic missions, which perhaps would qualify under jure imperi, whereas purely profit-driven or commercial undertakings are classified as jure gestonis. This distinction becomes interesting and most noteworthy in Congreso, which stresses that immunity is on the nature of the transaction rather than the entity's status. Philippine Admiral suggests that the differentiation between a vessel used for sovereign objectives and one engaged in quote-unquote commercial activity operations, concluding that only the latter could be subject to civil litigation and enforcement measures. Argentum, the most recent case in this history of long and fascinating, to my opinion, cases, analyzes and emphasizes this very question. The court's analysis discusses whether the particular activity, in this case, salvage and the subsequent disposition of cargo, can be deemed as an exercise of sovereign authority or transactional commercial affairs. Maritime liens, including salvage claims, present a distinctive challenge in this context. The traditional attachment of the ship or cargo can follow the property even after change of ownership, thereby enabling claimants to seek enforcement against the vessel itself. Courts have examined liens incurred under commercial conditions, and despite a state's enforcement, states' subsequent assertions on sovereign immunity need to be determined and decided very, very carefully. The Lotus case posits that a state may exercise jurisdiction unless a prohibitive rule of international law prohibits it or forbids it. In contemporary maritime law, this principle resonates with the notion that a state can assert jurisdiction over foreign vessels engaging in commercial activity within their territory waters, and provided that no overriding international legal constraint harnesses them towards a bind or a stronghold. While the Lotus claim arose in a criminal jurisdiction context, its broader significance lies in reaffirming the jurisdictional competence which is presumed unless explicitly curtailed. Modern doctrines of restrictive immunity fine-tune this presumption by exempting jure imperi activities from adjudicative and enforcement jurisdictions, but leaving jure gestonis undertakings open to legal scrutiny from courts. What then remains our takeaway? Well, the Argentum case reflects on all of these questions in depth. It discusses restrictive immunity, distinguishing genuine government functions from commercial undertakings. It also showcases that states that enter the marketplace, such as through chartering vessels for profit, entering salvage contracts, or transporting goods for trade, the shield of immunity yields to private law remedies. The Lotus case endures in maritime law as a foundational principle. It also states and asserts that jurisdiction, unless a limiting rule of international law, applies. Contemporary practice of this principle with restrictive theory, once it is established that the state's activities are indeed jure imperi, immunity bars jurisdiction and also adjudication. If those activities are jure gestonis, private parties retain the right to litigate or enforce judgments, including the possible arrest of vessels. This reconciles with Lotus's expansive presumption of jurisdiction with modern immunities, aligning well with the balancing objectives set out in one of the cases mentioned earlier, namely Congreso and also the Philippine Admiral case, both of which stressed that the court must evaluate the nature rather than merely the purpose of the activities. Well, from a political or a policy standout perspective, the interplay between these activities requires much deeper standing. Maritime regulation safeties and also commercial aspects of domestic systems require a deeper concentration and study of these. In reconciling these various differences, the courts must provide a framework in which private claimants can recover damages or enforce maritime liens without compromising genuine sovereign immunity activities. Even though the Lotus predated the modern articulation of state immunity, its core reasoning, permitting jurisdiction in the absence of a prohibitive norm, underpins today's system of restrictive immunity by making clear that states cannot preemptively prohibit scrutiny of commercial acts. Thus, any claim to immunity must be tested against the goal of ensuring maritime safety and fairness in international commerce, a policy imperative equally supported by commentaries that have been used in preparing for this paper. With those words, I thank the organizers once again for giving me an opportunity, and knowing that I've left 5 minutes, I'll be open to questions now or perhaps later. Thank you very much.
Oh, thank you very much, Ankit. I'm happy to report that your audio was very stable,
Splendid.
Very clear throughout the presentation, and the slides really helped us follow it very nicely. And that indeed you did not need for adjustments to be made to your allocated time, given that your presentation was nice and concise, just as we like it. My suggestion is that we still keep the format that we have in place, which is to hear from the 3 speakers in turn, and then we can have a nice general debate on the basis of the presentations. And that is why I will invite now Eli for Rao